Well, hello there. How is everyone? I hope you're all well on this beautiful, beautiful Friday. I know B's and F's, they don't go together, do they? I don't know. I'm still in shock. I'm still in shock. But anyway, you're looking amazing, by the way. And we're going to get straight into the meat and potatoes because it's Friday and you've got better things to do. Video 2, this is video 2 of 2. If you didn't see the first one, go check it out. Because it was really my thoughts and feelings and anger on what happened in court yesterday. And this video is talking about how the media are pushing out what happened yesterday. So we can just get a feel and a gauge on the local Idaho media surrounding the shit show that was yesterday's I don't even know what to call it. But yeah, let's have a look at it together and see how they're putting the spin on it. So this is the Idaho Statesman, this is. So judge in University of Idaho murder case rebukes Brian Kohberger defense team for juror phone survey. It's got a picture there. The judge in the University of Idaho student murder case admonished Brian Kohberger's attorney at a hearing Thursday over the defense survey of potential jurors that prosecutors argued likely defied the court's gag order and for alleging he violated her client's constitutional rights by halting the poll, which absolutely did. Without a doubt it did, and Ann Taylor should have pushed that further home. There was no reason for anything to be halted because ultimately that survey didn't go do anything in terms of going against the gag order. It didn't, because the information contained within that survey were already in the public arena. They were out there for all to see. And after that hearing, a lot more people heard it. Judge John Judge of Idaho's 2nd Judicial District in Latah County chided Ann Taylor, Kohberger's lead public defender, for the types of questions included in the survey of county residents, as well as for the way in which he learned about it from prosecutors after a phone poll of hundreds of prospective jurors was already finished. 400. Less than 1% of the community, but that's not the point. The point being that the survey didn't go against the gag order. There was no issues with it whatsoever, and if there was that much of an issue about it, why would they then have shared all the questions to thousands and thousands of people yesterday in a public court hearing? That kind of was a bit, I don't know. Right, so there we go. The thing is, as well, what the issue was is how the prosecution actually teed that up. He didn't know what was going on. Judge John Judge, sadly, in my opinion, is very easily controlled by the prosecution. Bill Thompson says there's an issue, so he automatically thinks, oh, there's an issue, fuck, shut it all down. Judge John Judge of Idaho's 2nd Judicial District in Latah County. We've just read that bit, haven't we? The survey is part of the defence's efforts to justify a change of venue out of the county for Kohberger's anticipated trial. I like the word in here. Efforts to justify a change of venue. Efforts to justify. It's not an efforts to justify, is it? It's an effort to determine whether a change of venue is required in order for their client to obtain a fair trial in the state. That's what it is. Very clear. This was a total shock to me, Judge told Taylor on Thursday, because this is a big deal and I take it very, very seriously, and I was surprised. Okay, that is what happened behind our backs, my back. Why does she have to tell anyone? Why? Please tell me why she had to tell anyone. In this hearing, he said, we knew there was going to be a survey. We knew that. So what they're saying is they knew there was a survey. So the survey weren't behind the backs. What they didn't like was the question. It weren't even that Judge John Judge didn't like the questions. Bill Thompson didn't like the questions. He didn't like the questions because the questions proved bias in the community. He didn't like it. So what he wants them to do is retract those questions, set out his own set of questions that are not going to be answered effectively to determine bias, so he can retain this trial in Latah County. That's what this is about. and the little elf man was angry. At the urging of prosecutors, but Judge barred attorneys on both sides from contacting possible jurors in a court order last month, which shouldn't have happened. Now I'm being accused of violating due process, which is a whole big issue for me, Judge said. Well, don't do it then. You literally set up an order without allowing the defence to have a discussion to fight their corner. And all Ann Taylor would have had to have done was referred the judge to Section 2B of their documentation that specifically stipulates that she is allowed to discuss what is already out in the public. What is already out in the public, what the public have been subjected to, can be utilised. Koberger, 29, is accused of killing 4 University of Idaho students in November 2022. Prosecutors plan to seek the death penalty if a jury convicts him through a trial, though a trial date is yet to be set. The victims were seniors Kaylee Gonsalves, Madison Mogan, both 21, and junior Xana Knodel and freshman Ethan Chapman, both 20. 3 women rented the off-campus home in Moscow where they were stabbed to death while Chapman was staying the night with Knodel, his girlfriend. Koberger attended the hearing in a black suit and tie, seated next to Taylor with no other defence attorneys present in the courtroom. Later, County Prosecutor Bill Thompson was joined by Ashley Jennings, his office senior deputy prosecutor, for the hastily scheduled and lightly attended hearing. Well, it didn't even have to get to this hearing, to be fair. Held at the Laytown Moscow police investigated survey. So yeah, they're also Bill Thompson goes to the cops and basically says, "Look, you need to get out there and find out what's being said. What do they know? What do they know? What do they know? Find out who's been contacted, exactly what they've been." So that was done as well. Bearing in mind again, nothing's been violated here. Nothing at all, but prosecution tells the police to go out and and find out what's been said and who's been said. And they're talking about getting their actual phone numbers and do you know what I mean? We don't care about surveys as long as they are written by us, the prosecution, and they're not effective. We care about these particular questions asked in this particular survey. Thompson told the court Thursday, just because they're put in the form of a question doesn't change the fact that they are affirmative representation of a fact, that if the listener was not aware of it now, they have been tainted by it. How many people do you think you tainted, if that's your way of it? Now this has been live streamed across platforms like this, everywhere, to thousands and thousands of people. You fucking idiot. And and that's what this is about. They have to go out and understand if people have been subjected to this information. That's the point of the fucking survey. How do you obtain the knowledge of who and what has people been subjected to by way of it? He even himself said that not all of this information is factual. Some is some potentially factual, some not. But you have to ask these questions. You have to. And this information is already out there. Doesn't matter whether Bill or Bob or Mary has seen it now. They might see it later on down the line. We've got another year before the trial happens for a start. But you have to obtain information on what people who are out there are potentially seeing and how it's settling. He said 400 people were surveyed would likely to be disqualified from being called as prospective jurors in the Koberger case if the trial stays in the county. Judge indicated he agreed. When prosecutors learned of the polls last month, they contacted Moscow police to investigate. The defence suspected the defence was behind it. Like this was done in fucking secret. But waited to lodge their complaint with Judge until they had enough information to understand whether or not it may be problematic. Thompson alleged that the defence had, whether willingly or inadvertently, violated the court's standing gag order that prohibits attorneys in the case from any public statements about it. But they can go to the public and speak to the public and discuss things that are already in the public arena. I can guarantee that if I went down to the bar and had a few drinks and was talking with some people and saying, hey, did you know about the Koberger case? The defence would, and the defence found out about it, they would go ballistic, Thompson said. And for good reason. That should never happen. So again, this is what I don't get with this. He understands there's going to be a survey. Understands that. That's what he says. By his own admission, I understand there's going to be surveys. I ain't got a problem. I can go and get a survey anyway. So I don't know what this bit of information, if I'm talking at the bar, has got a problem with it. He knows there's going to be a survey. What he don't like is the fact that the questions in that survey prove bias. And that's, I don't need, that's all it is. And he wants questions that he knows are ineffective. He's not stupid. He's been doing this job for 40 years. I nearly said 400 because I was looking at that there. Taylor acquiesced when challenged by judge, but vented frustration over a legal process that did not allow the defence to continue its work ahead of a looming deadline after this month to file briefs justifying its position for a change of venue. She also pushed back against suggestions that the questions in the poll broke with the requirements of the judge's gag order and stated the 400 residents surveyed represented less than 1% of the county's population, which is fucking pointless. That wasn't the argument that she needed to use. The only argument she needed to use was that she is allowed, as stipulated, I can't stress enough, by their own rules set in place, that she can discuss stuff that's in the public. Just the way it is. The prospective trial destinations could be Ada County or either Bannock or Bonneville. So something else that she was forced and railroaded into speaking about publicly. Koberger case isn't on the front page of the newspaper each day so they're just talking about why. Go down a little bit further. I think that's it. I mean, I could just make the decision right now, but I'm not an expert about the surveys. He said, I want to make the best decision I can if possible. And that was his outer statement on that. And Ann Taylor hadn't even brought the professional in all this forward. He was literally sitting there on Zoom waiting to go, and she didn't even bring the guy out. The guy who's been doing this for years, who has already done it in this state, she didn't even bring him forward to fight Brian's corner and say, I'm doing this, and this is why I do it, and this is why I've done it this way. Instead, she basically said, well, if you want me to start again from scratch and change the questions, I'll do it. What the fuck? Oh, my God. If you ever find yourself in trouble, especially trouble at this level, especially if you find yourself in trouble and you didn't do it, don't get yourself a public defender. Don't do it. Titanic. Don't let go, Jack. I'll catch you all in the next one.